I beg to mention item 5. But in fact, here, my lord, the process of remission is going on. Learned friend, my lord, may obtain the instruction. I don't know what is the outcome. The lordship may defer it for 2 weeks, my lord. In the meantime,
In the earlier week, we have the directed to get a report from the government personnel regarding process of revision. That we would have indicated twice, but responsibility from their side.
Mr. S.K. Tolkar, Commander Deputy, by referring to the previous or past in this completed the process of emission of the substance is being considered.
Yes.
Is under consideration and the learned additional public prosecutor was asked to obtain instruction on 20 about the status of the revision report of the MS stage order. Are ordered to obtain
maybe on criminal appeal, I have filed on 18.
new criminal case.
New. Monday, my lord. It is
Monday.
jail.
Tuesday? Tuesday?
That's it. Tuesday, my lord. My lord. Tuesday, 30. My lord.
I beg to mention criminal or order may come up on next week.
Orders next to next week. Already we have picked many matters. For what? Orders for what?
Orders for both the in both the matter, they are in behind the bar.
So suspension.
I am not.
I have people who lost it. I didn't.
Second. 8.
7 and
Yes.
may not like to take up the
Is it so? For what reason?
fee Hazarika.
Oh. is the it for the matter before any other without one of a bit louder, madam.
May I please your lordship? I am here to mention the criminal petition number 224/2022, filing number 0248/2022, uh, and lordship seeking for date 03/05/2024.
Criminal petition
Yes, lordship.
challenging what?
Case name of party is the lordship Navjit Palan.
Challenging what?
Yes, lordship.
Challenging what?
Challenging. Actually, petitioner filed the petition for reducing the maintenance amount, and the respondent is
That might be before a single bench. Is it not? MS Bora, please clarify from the matter.
much of it.
May I please, Lordship? Lordship, before starting of the hearing, Lordship, before my senior started, Lordship, regard to item number 4, Lordship. Right now, my senior, he is out of station, Lordship, and he won't be take much time. He's praying for to take up the matter on Monday, Lordship. Our part only, Lordship. By in the morning, he will be covered everything, Lordship. He said.
Sunday
In the
would be
yes.
not sitting for the whole.
Any other appropriate date, Lordship? And in the meantime, it my
If
senior
arising out of same,
same connected matter, Lordship.
your
Same.
submission will be same for all the cases.
Confessional statement of all the accused
Arising out of same case, you will respond to one.
myself. Yes, only one.
Then today date, beyond heard of, because it will be picking up.
Yes, matter, but I every time they are that go through the order.
Why I have today
No,
date,
no, not this.
today date, beyond heard of any suppose this matter.
After
Can it be
third also not an issue, Lordship. After
Beyond
fourth,
third of May, I say.
on 6 May?
Six.
Monday.
6, 7 is holiday, sir.
Or what?
It's a election.
Then I have
Election.
Not big.
then it
After
lordship, then it will be 13th of
Doctor, you are in.
I'm item number 1.
lordship. It's a very voluminous case. We start now, lordship. Take time. So my submission would be let them start. If you want to make some 13th,
So-
let it
Today, if today,
not 13th or the matter will not change.
okay, but next tomorrow is Monday out, and again Friday out, and again Monday out,
Understand?
and again we lost memory. Not have that capacity of memory. The voluminous record in one
Day to day, lordship, very quick.
Right.
It will be easier
don't
for
decide yourself. E.com. Run it down for that. One. Who is in two? Who is in two? Who is in three? Three none. Mr. M. Hello. Trending on for was clear
CBI, CBI special
B. Chakma Lordship.
D.
Lot.
Council for as
CBI is the
and you start.
no not
No, you start.
not that is better. I was
Then you start. वही रह जाता How many witnesses?
30 with
30.
You have the paper book?
The name of the appellant is item number 1 is the Sahadev Chakmal.
Sorry.
Sahadev Khalabra. Exhibit
Have you made this index?
yes, sir.
Wait. Yes. Other council. Other council. Item 2. item 3. Yes, other two. Item number item number 4. But
Chakma, it's Chakma. It's not like
item number
for Pico to Village.
is that
Nobody is appearing.
because you have been asked it. We have to appreciate not piecemeal. We have to
Yes,
appreciate to understand our
Yes,
difficulties
yes,
also at
doctor,
the same
yes,
time.
yes, we have no need to know.
In February, you have been asked for all the appeals,
1 and 30 submitting. 2 and
1 in 3, 2 and 4. Your the objection of PP, carried. What is your urgency on your part?
Whole pending matter.
That is all clear, otherwise behind the bar,
Yes,
Yes.
sir.
serving their sentence.
Yes.
Why you are expecting?
The whole pending matter, not only this matter, all pending matter. That's the part. It's full.
And this is the situation. And let them file by next week. Take up. Mr. Dr. Current Council for Appellant in Sir Monday, Current Council for Appellant upcoming data spec index in reference to the order dated as the appellant in 3 2 and 4 have not submitted their respective text. The same has been in period of 1 week. Now, if it goes, okay,
I'm sorry,
if
Lordship.
there are 1, is that I think
Sorry, Lordship. I cannot.
Pleasure.
you have to understand how difficult it is.
Yes, sir.
Here I
But,
according to the index and 3 without but you have to apply all for it.
value.
Need visual. Here in this case, I am appearing as an amicus. And Lordship, the case was registered under section 302/34 and thereafter
302
34,
Three zero
302
B and
and 304B
dowry.
Against
originally raised.
originally registered
Originally
against
raised
3%.
302 34.
Yes, originally registered 302/34
30.
and it was registered against 3 persons: Abhijit Paul, that is the petitioner appellant before your lordship, and Srimati Bibha Paul,
Mother of Abhijit.
yes, mother of Abhijit Paul, and a sister-in-law
One
of the
sister.
but my lord, when the charge sheet was submitted, they
Why the
were
charge sheet?
discharged.
Wait, sir.
My lord,
Why the charge sheet?
charge sheet.
Page 66. Page 67.
Yes. It's given those in custody.
Reject.
70.
Section 34 of the Dowry Prohibition Act.
Yes.
Viva Paul and sister-in-law Rakhi Paul.
Yes,
So charge sheet was submitted only against the appellant
only against the
under section 302 IPC with headed section 3 and 4 of the Dowry Prohibition.
Dowry.
And charge
then charge was framed under section 302 and the 304B.
Okay.
That your lordship will find
let
that
us have the FIR. Let us read that.
Lordship, take 1 minute, 2 minutes break. I'll just come.
2 minutes break for hearing or your absent?
page number 4.
Hmm.
The officer in charge of the police station informant so and accused so and so. Sir, with due respect, I beg to state that accused number 1, the husband of my daughter, Juma
That's correct.
Paul is the my daughter had been leading her conjugal life with accused number 1 in a tenanted room at Hojai Govindapalli.
Tenanted room.
Tenanted room at Hojai Govindapalli for 2 years, and in course of that time, accused number 1 used to torture my said daughter both physically and mentally on several occasions, demanding that being unable to bear the
brand of torture meted out to her by accused. Number one, my daughter took shelter in my house along with her 14-month-old son. Had been in my house for 2 months. Around 6 p.m. on 16/01/2016, accused number one came to my house and promising that he would not subject her to any kind of torture. He stayed in my house. At 12:30 a.m. on 17/01/2016, accused number one strangled Zuma on the bed itself. I myself witnessed the incident. The accused number 2 and 3 are indirectly involved in the incident. Here, my allegation is that at about 12:30 a.m., accused number 1 strangled Zuma on the bed. But when, my lord, the evidence was left, this was absent. Then, my lord, this case was registered. Thereafter, police searched only against this accused person, and others were charged. Thereafter, charges were framed under section 302 and 304B that your lordship will find at page number 6. Then, as many as 11 witnesses were examined, and
Come
there
to the index of the just give the finding with PW1.
PW1 is the Emily Borua she did the inquest.
Two.
Two is the informant and
Mother.
mother of the deceased, and
Three.
he is the only eyewitness.
Three.
I am talking about two.
With three.
Three is the father of the deceased.
Okay.
Who is
Four.
the father of the deceased,
Four.
and three are their relatives.
Four relatives.
Relatives.
Five relatives.
Five.
Okay.
Five is
Let us,
also
let us proceed. PW2.
PW1
One and inquest.
inquest. Lordship. My lord,
It was done on 17/1.
17. On 17/1/2016, while I was working as circle officer of Dai Revenue Circle, on that day, on the basis of police requisition received in connection with Dai PS PDNT number so and so, dated so and so, I conducted the inquest on the dead body of victim Zuma. The dead body was identified by Renna. During the period of inquest, I found some marks around the neck, but where it is not specifically. Later on, the dead body was sent to PP Civil Hospital Bhogao for postmortem examination. As per report received from police and witness, the woman was strangulated by her husband. To ascertain the cause of death, the body was sent for postmortem. Exhibit 1 is the inquest report submitted by me. Exhibit 1 is my signature. The witnesses signed on the inquest report in my presence after completion of the inquest report. I did not submit the police requisition along with the inquest report. I did not mention any identification mark in the I found the body was in stiff condition. I gave my opinion as per verbal statement of exhibit. PW2 is the Sathi mother of the informant, and she claimed herself as an eyewitness. I am the informant of this case. Accused Abhijit Paul is my son-in-law. My daughter Juma Paul got married to accused about 3 years ago. After the marriage, both of them had stayed in Shillong for a year, and thereafter they started staying in tenanted house at Govindapalli, Hojai, and since then the accused used to pressurize my daughter to bring rupees 2 lakh from us. My daughter informed me of the same by coming to my house. We could not pay the said money owing to our poverty. The accused assaulted and tortured my daughter as we could not meet his demand. As a result, my daughter came back to my house along with her child. The accused had gone to our house 10 days prior to the incident and demanded rupees 2 lakhs from us. Since we could not meet his demand, he made a nuisance and left my house. My lord, these facts were not stated when my lord fire was when my lord he was given her 161. On 16/1/2016, he accused came to our house again and said that he would not subject my daughter to torture, demanding money. I told my son-in-law to stay in my house. He went out for a walk. After taking evening tea and returning home, he took the meal. Thereafter, I told my son-in-law to stay in a room along with my daughter. Around 12:30 a.m., I heard the child of my daughter crying, whereupon I entered that room and saw my son-in-law strangulating my daughter by sitting upon her chest. Then I removed the hands of my son-in-law and sounded an alarm. My husband got up and came there. Other people also arrived there. The accused tried to flee, but he could not do so. My daughter was finding it difficult to breathe. Then we took my daughter to Hodai Civil Hospital in an auto. But since she was not kept there, we took her to HAMM where she was declared dead. The accused was handed over to the police that very night. Police took the dead body of my daughter away. I lodged the Azahar the following day. Exhibit 2 is the Azahar lodged by me, wherein Exhibit 2 is my signature there. The dead body of my daughter was sent for PM examination. Fraud. In the Azahar, I mentioned the names of 3 accused. A person wrote the Azahar on behalf of me. I know what is written in the Azahar. The marriage of my daughter was solemnized at Kamaikya. The door of the room in which my daughter and son-in-law had slept was open. Door was open. The accused is a driver by profession. I do not remember whether I stated to police or not that we had got both of them shifted to Hodai from Ceylon. A festivity was going on near our house on the day of the incident, and the music was being played there. It is not a fact that door of the room in which my son-in-law had slept was not closed. It is not a fact that I had not removed the hand of the accused from my daughter's neck, and the accused had not squeezed the neck of my daughter. It is not a fact that I did not state to the police that I had removed the hands of the accused. My lord, that part, my lord, she has never stated before the police. And my lord, if we compare with the FIR, FIR version is a bit different because she has, in the FIR it has been stated she has been strangulated with the bed. Here, it is alleged that the accused strangled with his hand in his neck by sitting on her chest. At the time of incident, Monica Mondal and Taposi Das came to our house. It is not a fact that the accused was massaging my daughter as she was unwell and that he did not squeeze her neck.
So it was not contested that the accused was not in the house of the informant.
My lord?
Or it was not contested that the accused was not in the house of the informant on that day.
Yes, it is.
Or-
Accused has in his 161 statement also he said that I was there.
So from the trend of cross-examination, it is not emerging that the accused has contested that yes, he was not there. So it appears to be an position that the accused was there in his in-laws house.
Accused was there in the in-laws
In the
house,
night
but in the,
intervening 16 and 7.
but in the
Also
313
inside the room.
he was inside the room, and in 313 he said, in 313 he said,
What does it say? 313
313 lordship.
on that issue.
Yes. Lordship, page 34.
30.
Page 34. Here, first one is about PW1, second one is PW2, and answer. I did
Where is
not.
the answer? Okay. I did not.
I did not commit any such offense, and I was falsely implicated with this case. On the day of occurrence, I went to the house of the informant, where I saw she was doing massage on her daughter's body as she was feeling pain. Thereafter, I taking dinner and went to sleep. I have a minor son. Why should I kill my?
So it was an admitted position that he was disturbed.
He was in the room, but it has been. He stated that he
He
saw.
slept.
He saw.
After dinner, he slept.
Yes, he went and he went to sleep, and he saw that her mother was doing massage on the daughter's body as she was feeling pain. That was her statement. And 36, page number 36. Well, same thing. 36, Mala, 34 and
Ah.
36 are same.
It was good. Situation described by PW was good. That was his answer. Situation deposed by deposed by PW2.
Yes.
In responding to that, he has given this answer.
Yes,
Page
yes.
34.
page 30.
Okay.
He has given that.
Let us have
PW3, page 15. He is the father of the deceased, Virendra Nag. Well, here say, yes. The informant is my wife. The accused Abhijit Paul is my son-in-law. Both of them got married to each other some 3 years back. At first, they had stayed in Shillong, and after that, they shifted to Hojai and started staying in a tenanted house at Govindapur. Since my son-in-law used to assault my daughter hunting money, the latter had returned to our house. After my daughter's stay in my house for 2 months, my son-in-law came to our house and said that he would not assault my daughter anymore by demanding money. That day, after taking tea, the accused went out for a walk. He returned to our house again, and after having meal, he was sleeping in our house itself. My daughter and son-in-law were in a room. At night, since my granddaughter was crying, my wife entered that room and saw my son-in-law squeezing the neck of my daughter by sitting upon her chest. My lord, he is deposed, my lord. Her wife saw, but he had not witnessed, but her wife saw the incident, and thereafter, my lord, it was told to him. Then, as my wife sounded an alarm, I got up and went there. Other people also arrived there. The accused was kept apprehended. Then we took my daughter to civil hospital, but as she was not kept there, we took her to HAMM hospital where she had declared dead. Later, my wife lodged an azhar. Cross. The marriage of my daughter and son-in-law was solemnized in Kamakhya, Guwahati. The house of the accused was at Shillong. Police interrogated me on the following day of the incident. It is not a fact that I know nothing about the incident. I stated to the police that we had got my daughter and son-in-law shifted to Hojai from Shillong and made them stay there in a tenanted house. My granddaughter was born in the tenanted house itself. My son-in-law visited our house once during the period of 2 months. I stated to the police that since music was being played over loudspeaker, I could not know about the incident. My daughter was not capable of speaking when I saw her. She breathed just 2-3 minutes. It is not a fact that the accused had not committed any assault on my daughter demanding money, and that I had not seen him squeezing the neck of my daughter. It is not a fact that my daughter died of illness. Lordship PW4 is Sri Ashish Day is also hearsay witness. Informed Sathi Nag is my younger sister. victim Juma Paul was my niece and accused Abhijit Paul was the husband of my said niece. The incident took place at 1 a.m. on 16/1/16. I was at my house. One Robindra Day rang my younger brother Sanjit Day up and informed him that my niece Juma Paul was seriously unwell. When Sanjit informed me of the same, I, accompanied by my younger brother Vijit Day, went to the house of my said niece. On finding the condition of Juma to be very critical and seeing my younger sister wailing and weeping, I immediately took Juma to civil hospital, Hojai. My younger sister also accompanied me there. We also took the accused along. The doctor declared my niece dead. Later, my younger sister Sathina told me that accused used to torture my niece, demanding rupees 2 lakh. My younger sister also told me that accused had strangled Juma by sitting upon her Juma's chest. My niece informed me about the accused person demand of rupees 2 lakh. A black mark was present on the neck of my niece. At the time of the incident, I was not present there. The house of my younger sister is about 3 kilometers away from that of mine. A lot of people had already gathered there when I reached the PO. I did not state to the police that when we were taking her Juma to the hospital, my younger sister Satinag and the accused also accompanied me. It is not a fact that my younger sister did not tell me that accused had strangled Juma by sitting upon her chest. It is not a fact that I did not state to police that there was a black mark on the neck of Juma. It is not a fact that I have adduced false evidence. Regarding that black mark and all, that has he never stated before police. PW 5, Sanjit Chandra Day. Informant Satynak is my elder sister. Victim Juma was my niece. The accused is the husband of my said niece. Around 1 a.m. on 16/1/16, Robindra Day, a neighbor of my elder sister, informed me over phone that the condition of my niece Juma was very critical and that I should go there immediately. Then I informed my elder brother Ashish Day of the matter, whereupon Ashish Day, accompanied by my younger brother, rushed to the house of the said niece. Later, my elder brother took Juma to hospital, where the doctor declared Juma dead. My elder brother informed me these things. I rushed to civil hospital Hojai and took stock of the incident. Then my elder sister Satina said that accused had strangled Juma and that the accused had been torturing Juma, demanding rupees 2 lakh from her a couple of months prior to the incident. My niece also intimated me about the same. Being unable to bear the brunt of torture meted out to Juma by her husband, she had been under shelter in the house of my elder sister. The accused also tortured Juma by going to the house of my elder sister 10 days prior to the incident. When an executive magistrate held inquest on the dead body, I was present there. Exhibit 1 is the inquest report, wherein Exhibit 1, 2 is my signature. It is not a fact that I did not state to police about Robindra Day made a phone call to me. It is not a fact that I stated to the police that on getting the information that Juma was unwell, I had sent my elder brother. It is not fact that my elder sister did not tell me that accused had strangled Juma. It is not a fact that Juma did not inform me about accused person's demand for rupees 2 lakh. It is not a fact that Juma had not been under shelter in the house of my elder sister since 2 months prior to the incident. It is not a fact that I did not tell police that I had noticed a black mark. It is not a fact that I have used false evidence for the sake of my needs. PW6, Taposi Das. Informant Satinag is my neighbor. I know the accused. The incident took place at night on 16 January 2016. Around 1 a.m., hearing the hue and cry in the house of the informant, I went there and found Jumana dead. She was not breathing. Obhijit Paul was standing nearby. Uh, the informant was weeping. The informant told me that the accused had strangled her daughter Juma. Satinak heard the sound of foot thumping of her daughter against the bed. The accused is the husband of Juma. Later, Juma's maternal uncle came and took her to a doctor, and doctor declared her dead. I heard that there was quarrel between the husband and wife, and that Juma said that Obhijit had demanded rupees 2 lakh. I noticed red mark on the neck of Juma. Well, up to this, my lord, it is very much clear, my lord, at the on the after the on that particular day, the accused was well inside that room, as per the version of the accused. All the is up to PW6. Cross. At the time of incident, music was being played over loudspeaker at a short distance away from the PO. Going there, I found Juma's parents there. It is not a fact that the informant did not tell me that the accused had strangled her daughter. Police interrogated me in the house of the informant. It is not a fact that I did not state to the police that I had informed the maternal uncle of Juma of the incident. It is not a fact that I did not state to the police that I had noticed a red mark on the neck of Juma. It is not a fact that Juma did not tell me that the accused had demanded rupees 2 lakh. It is not a fact that I have adduced false evidence. Hello, regarding this demand of 2 lakh, Lordship, because it has been alleged that it was demanded 2 months prior to the incident. But regarding that, there is no FIR and all, and nothing. PW7, Subhas Muzumdar, he said, I know the informant and the accused person as well. The accused is the son-in-law of the informant. The incident took place in 2016, around 1 a.m. On the day of the incident, hearing commotion in the house of the informant Satina, I went there and saw Juma lying on a bed. Juma was the daughter of Satina. A lot of people had already gathered there when I reached there. Later, he was taken to a doctor and the doctor declared her dead. I heard that Obhijit had assaulted Juma, demanding rupees 2 lakh 10 days prior to the incident, and that the accused had strangled Juma. He is also hearsay witness. In cross, when I reached in the house of Satina, I found some 15 to 20 gathered there. I had witnessed Obhijit assaulting Juma 10 days prior to the incident. It is not a fact that Juma did not tell me that accused had demanded 2 lakhs from her. I saw about Obhijit sitting on the bed. He saw Obhijit was sitting on the bed. So, my lord, it is not that he has, after the incident, he has fled away. It is not like that. He was very much present. It is not a fact that I have adduced false evidence against the accused. PW8, Srimati Monica Mondal. I know the informant and knew her daughter Juma as well. I know the accused. Around 1 a.m. one night in the year 2016, hearing the sound of Halla Bol in the house of the informant Sathina. I went there. Sathina was wailing. On being asked, Sathina replied that Juma had been strangled by her husband Abhijit. I, I saw Juma lying on the bed. She was not taking her breath. I noticed a mark in the neck of Juma. Abhijit had a quarrel with Juma 10 days prior to the incident. Seeing Juma weeping, I asked her as to what had happened, whereupon she replied that Abhijit had assaulted her, demanding rupees 2 lakh. Cross. Police visited the PO the following day of the incident. Police interrogated me. It is not a fact that I did not state to police that I had noticed a black mark on the neck of Juma. It is not a fact that I did not state to police that when I had asked Juma 10 days prior to the incident, she had replied that Abhijit had assaulted her, demanding rupees 2 lakh. Music was being played over loudspeaker at a little distance away from the PO. On my arrival at the PO, I found some 15 to 16 persons there. It is not a fact that accused had not strangled Juma. PW9. Indra Day. Informant Sathina is my neighbor. Mrs. Juma was her daughter. The accused is the son-in-law of the informant. The incident took place on 16/1/16, some 1.5 years ago. Around 12:31 a.m. on the night of the incident, hearing the sound of Allah Bolo and cry in the house of informant Sathina, I went there and saw Juma lying on the bed. Her parents were weeping by sitting near her. On being asked, the mother of Juma Paul replied that accused had strangled Juma. Then I informed the maternal uncle of Juma of it over phone. Juma's maternal uncle came and took her to the hospital, but she expired. Abhijit Paul attempted to flee from the scene, but we kept him apprehended. But such type of statement, except her, no one has made. 10 days prior to the incident, the accused had assaulted Juma, demanding rupees 2 lakh from her. I witnessed the said incident. It is not a fact that no incident took place on 16/1/2016. There is a house in between the house of the informant and that of mine. It is not a fact that I did not state to police about my calling Juma's maternal uncle over phone. When I reached there, the accused was inside the room. It is not a fact that I did not state to police that accused had attempted to flee the scene. It is not a fact that the accused did not involve in any quarrel demanding rupees 2 lakhs. PW10. Dr. Nobozwan Bora. He is the medical officer who done the on 17/1/16, while I was working as senior medical officer at BP Civil Hospital. On that day, I conducted the postmortem on the dead body of victim Juma Paul, a 21-year-old female body, on the basis of police requisition in connection with Buzai PSED entry number so-and-so dated 17/1/16. The dead body was identified by UBC 1220 so-and-so and Virendra Nag and Surojit Dey. On examination, I found chymosis seen approximately 5 cm length into half cm breadth on right side of the neck, reddish in color, and her face was pale and lips kynos on the back of neck. As per my opinion, the death was due to throttling or mechanical obstruction of air passage, asphyxia due to throttling. Matlab in two parts, matlab due to throttling or mechanical obstruction of air passage, asphyxia due to throttling. Exhibit 3 is the PM report submitted by me, and Exhibit 3.1 is my signature. Cross. I examined the dead body on 17/1/16 at 1:30 p.m. This is important. I did not mention specifically how and by what substance the mechanical obstruction was caused. I did not mention the time of death of the person. Death can be caused immediately within a second after obstruction or throttling. It is not a fact that I did not properly examine the dead body. See, PW 11, SI Nokul Chandra Fukan, he is the investigating officer. He deposed on 17/1/16, I was working as SI of Hojai PS. On that day at 1 p.m., informant Sathi Nag filed an FIR at Hojai PS due to committing murder of her daughter by the accused Abhijit Paul, her son-in-law. After receiving the FIR, PW 11, SI Nokul Chandra Fukan. On 17/1/16, I was working as SI of Hojai PS. On that day, at about 1 p.m., informant Sathi Nag filed an FIR at Hojai PS due to committing murder of her daughter by the accused Abhijit Paul, her son-in-law. After receiving the FIR, the OC of Hojai PS registered the case and endorsed me to investigate the case. I went to Hojai FRO to see the dead body of the victim, Juma Paul. I have taken the dead body of the victim as well as accused Abhijit Paul to PS and sent requisition for committing inquest over the dead. I visited the place of occurrence and wrote a rough sketch map and recorded the statement of witnesses. In the meantime, CEO of Hojai, Imli Borua, done the inquest and sent the dead body for PM to PCH Nagaon. On the same day, I also recorded the 161 statement of the accused, in which he confessed his guilty. In his statement, the accused stated before me that on the night of 16/1/16, the accused took alcohol, and when he back to home, his wife was angry for taking alcohol and his wife offered dinner. But he slept without taking it, and at night he strangulated his wife Juma Paul, due to which she died. I also seized one mobile phone from accused Abhijit Paul and forwarded him to jail hazard on 18/1/16. I have collected the inquest report and PM report and completed the investigation and filed the charge sheet against the accused Abhijit Paul under section 302 IPC, added section 3/4 of the DP Act. Exhibit 4 is the charge sheet submitted by me, and Exhibit 4.1 is my signature. Exhibit 5 is the inquest report, and Exhibit 5.1 is my signature. Exhibit 6 is the seizure list of mobile phone, and 6.1 is my signature. This is important, my lord. Exhibit 7 is the CD. Exhibit 7.1 is the 161 statement of the accused Abhijit Paul, and Exhibit 7.2 is the signature of the accused in the said state. So, my lord, his 161 statement was exhibit, and the trial court, while convicting the accused person, heavily relied on this 161 statement. And the 161 statement made before the police, that is inadmissible in evidence.
It's part of the
In the, my lord, page 52 is the, my lord, paper book exhibit 7, that is the exhibit portion, mention exhibit 7. And,
in which paragraph?
yes, my lord, I'm coming to that. My lord, page 47 of the paper. Page 47, paragraph 9. May I read? The investigating officer, EW 11, SI Nokul Chandra Pupon, has stated in his evidence that on 17/1/16, at about 1 p.m., informant Sathinaak filed an FIR about committing murder of her daughter by accused Abhijit Paul. After receiving the FIR, the OC registered the same and endorsed him for investigation. He visited the place of occurrence, draw a rough sketch map.
That also
Lordship.
the reproduction of the to 11.
Yes.
So in which part of the judgment portfolio has relied upon?
Lordship, subsequently, Exhibit 7 is the CD, 7-1 is the 161 statement of the accused Abhijit Paul, and Exhibit 7-2 is the signature of the accused in the state statement. Correct?
Now, in the subsequent paragraph, where that was referred to by the learned trial,
In the cross, nothing has been substantially departed from, rather than the statement of witnesses recorded by him has been substantiated. In the cross, he stated that in the statement of Imli Burwa, the GD entity number so and so is wrongfully. Nevertheless, such clerical error, in my opinion, cannot sweep away her testimony and discredit her evidence. One 161 statement of accused Abhijit Paul, and Exhibit 7-2 is the signature of the accused in this state statement. In the cross, nothing has been substantially departed from, rather the statements of witnesses recorded by him has been substantiated. In the cross, he stated that in the statement of Imli Burwa, the GD number 378/16 is wrongfully recorded and it should be 370 dated 17/1/16. Nevertheless, such clerical error, in my opinion, cannot sweep away her testimony and discredit her evidence. Lord, that has been said, my lord, that was that ought to have been 370 instead of 378. And lordship is correct. Though in that it was exhibited, but the trial court, while passing this judgment, did not emphasize on the my lord exhibit that my lord exhibits. Lordship? No, lordship, actually, I have overlooked it. I apologize for. But my lord, when my lord the document is not admissible in evidence, not to have been my lord, exhibited. That is also. My lord, I have not completed the cross-examination part of the PW report. In cross of PW 11, page 32, cross, Dhirendra Nag informed to PS over phone that his daughter was killed by his son-in-law Abhijit Paul. The OC has entrusted him to investigate the case on 17/1/16. at about 2:40 p.m. On 17/1/16, the date of occurrence was at 12:30 a.m. and date of report was 17/1/16 at 1 p.m. and date of action taken was 1:45. No sufficient evidence was found against the accused party. He has clearly exposed.
Now, what is your start?
Yes, my lord, I'm just not, my lord, this is important, my lord. In cross, my lord, she has deposed, my lord, no sufficient evidence was found against the accused party. My lord, in the paper book, my lord, page 30, my lord, page 32 in cross,
32.
page 32 of the paper in cross portion.
Yes.
He has, my lord, in fourth line, okay. My lord, he admitted, my lord, no sufficient evidence was found against the accused. It is not a fact that in the copy of FIR which was furnished to accused, the date of occurrence is mentioned as 17/1/15. Not thumb impression of accused has been taken by me, and the injury mark of the dead body did not match with the dead body's injury report. This is also fact. As per statement of Sathina recorded by me, there is no date is written by me. In the 161 statement of Sathina, in the middle part of the statement copy given to the accused shows the date as 6/1/16. The FIR was written by some other person. Sathina did not tell before the police in 161 statement that his daughter and son-in-law sleeping room was open. She also not stated before me that the meeting with music which was held nearby her house. She has stated before me that the hand of the accused was not removed. My lord, that part is also vital, my lord, because PW2, my lord, the witness, he deposed that he found her son-in-law throttling the neck of her deceased by sitting on the neck, and she removed his hand. But regarding, my lord, removal of hands and all, my lord, she did not state before the police. So, my lord, that is a developed version when she was adduced her evidence before the court. She did not state before me that at the time of occurrence, Manik Mondal and Taposi Das came to her house. I did not take the statement of Mrs. Imli Borua to conduct the inquest. Who conduct the inquest? The inquest report was collected from the circle officer. The title Nag was wrongfully written as Nath in the copy of the statement of PW1, Imli Borua. In the statement of Imli Borua, the GDNT number 37816 is wrongfully recorded and it should be 370 dated 17/1/16. When we had visited the place of occurrence, then the door was found open. So, my lord, when he visited, then also he found that the door was found open. In the adjoining room at a place of occurrence, I have not mentioned who were stayed there. My lord, he while preparing the rough sketch map and in his chart sheet and all, he did not mention who were present in which room, and next day of the date of occurrence, the police has taken my statement at the place of occurrence. PW4 Ashish Day did not state before me that his house was about 3 kilometers away from his house. He stated before me that the informant and the accused was taken to hospital. PW4 did not stated before me that though the victim Juma Paul has mark on the neck, but he did not state before me my lord, regarding my lord, mark on the neck, there is a vital difference. Someone says it's red, someone says uh, black spot, and the inquest also different inquest report. And in the cross, my lord, PW5 did not state before me that Juma Paul was not torturing her. No name has been stated before me about phone call given by Rotindra Dey. PW5 also did not state the victim demanded her husband rupees 2 lakh. He has told before me that black mark has been seen before police. PW6 did not state before me that accused was sitting nearby. PW6 did not state before me that Juma's maternal uncle gave information also that there was red mark on the neck of the victim. PW7 did not state before me that he had not seen the black mark on the neck of the victim. He did not state before me that Juma's father did not inform him about the demand of money. PW9 did not state before me that Juma's mother called him, and when he went to the room, the accused also present and tried to run away. PW9 did not state. The statement given before you by the accused is not admissible in evidence, and you did not properly investigate the case, and the accused is totally innocent. My lord, from the FIR, it has been transpired that allegation is that, my lord, he stayed me in my house at 12:30 a.m. on 17/1/16. Accused number 1 strangled Zuma on the bed itself. This is the allegation in the FIR. But this allegation was not, my lord, it becomes different version when they were examined as PW. Only, my lord, eyewitnesses, my lord, PW2. Rest are, my lord, rest have not said that they have seen the accused person throttling, strangulating the neck of the deceased with his hand. Only the accused number 1. My lord, now the question is, my lord, whether the version of the PW1 is believable or not. That is the main, my lord, point to be, my lord. My lord, PW2, PW1 is the inquest, the person who did the inquest. PW2. Lord, in the inquest report, Lordship will find it is written some mark seen in the neck, around the neck, but it is not specific. Lord,
What is the
inquest,
evidentiary value of an
inquest report is just a, my lord, it should be corroborated, my lord. My lord, in the corroboration is required, but my lord, in the inquest report, my lord, it says some mark seen.
By the PM report,
Yes.
both test report I
But my lord, as per my submission, my lord, this is not corroborated. My lord, the inquest says, my lord, some mark seen. And as per her report, my lord, opinion, as per report and statement of witness, the woman was strangulated by her husband. To ascertain the actual course of death, body was sent to PM. In the PM, there says, my lord, own position and character, there icomosis seen. Icomosis means a dislocation of the skin resulting from bleeding. And it's approximately 5 cm in length and half cm breadth. Right side of neck, reddish face, pale lip, kainos on back of the neck. And my lord, my lord, they have, my lord, it has been in the PM report, mark of ligature on neck, that is absent. My lord, pressure mark, my lord, ligature, mark of ligature, there is no ligature mark. So, my lord, as per my,
It is not the protection that laser was strengthening her. It that
my lord, it is not that he was, not the case, my lord, he was strangled by, what we call,
It was bare hands.
with bare hand. So, my lord, there, my lord, ligature mark, there is no ligature mark, and no opinion. In my opinion, cause of death is due to throttling or mechanical obstruction of air passage. So, my lord, it is not concrete, my lord. In my opinion, my lord, it may be a cause of throttling also, or if any due to any mechanical obstruction of air passage, it may also happen, as per the report of the post-mortem. And my lord, it is also very interestingly to be noted, my lord, the accused was, my lord, he was all along present inside that room. He was all along, my lord, after the incident, he
Who?
was all along present.
Who?
The accused party. It is not that she had tried to fled him.
He.
He did not try to fled him. And my lord, when my lord,
the one
Yes.
the
accused stated, my lord,
answer number 7 on that day.
my lord, page 34, my lord, he deposed, my lord, he stated before in 1313, I did not commit any such offense and I was falsely implicated with this case. On the day of occurrence, I went to the house of the informant where I saw she was doing massage on her daughter's body as she was feeling pain. Thereafter, I taking dinner and went to sleep. I have a minor son. Why should I kill my wife? My lord, he, my lord, denied the allegation. My lord, whatever, my lord, deposed by PW2 and other witnesses, he simply said, at the time of, my lord, I went to the house of informant and I saw she was doing massage on her daughter's body as she was feeling pain. And thereafter, I taking dinner and went to sleep. Only that much.
Then the take of argument, the first then for to explain what happened. If the inside the sensitive side of the Kirkon.
Kirkon.
You need to take up.
My lord, that is there, but my lord, here I have only found, my lord, in the cross exam, in the
Because you stated you also explained in 13 that these two witnesses were different. They did not come after that. As if that goes to show, firstly, you were there. You were there.
Yes.
Right? That your explanation is that these two witnesses are deposing falsely. They did not come after that. The room. See? Meaning thereby you were there. Then the onus, someone
my lord,
shifted to you.
my lord, that portion, my lord, I have also not found in cross examination also.
The
That-
page 38 regarding was
Yes.
that day he did not come.
I have not committed any such offense on that day, he did not come to the place of
Ah.
occurrence.
Then PW9,
PW9 also,
his answer, he did not come to the place.
he did not come to the,
Answer relevant night.
on the relevant night.
Meaning thereby, you were there. So you were the person who witnessed him. Observed.
Yes, my lord, regarding that, my lord, thing has been come out from the, during cross-examination, that he has not offered any explanation while he was, why he was present and where and which place and which room he was there. That kind of, I have not found anything.
There was no cross-examination that you were not in the house of your mother-in-law.
That is also,
There was no cross-examination
there was
that
no
you were not
cross-examination.
with your wife inside the bedroom on that particular night.
My lord, inside the bedroom, that is
Inside
not
the room.
inside the
So
house.
he went sleeping inside the house.
Yes, I was sleeping inside the house. But in the cross-examination also, there is no, that,
There was no
But-
thing that you were not with your wife.
yes, that is, that kind of, cross-examination was also not there. Because my lord,
So
I,
it got oral evidence and medical evidence corroborate perhaps
but my lord, when the, my lord, the, this,
anything on the charges on 302, you have been convicted on 302 and 304B. Anything on
my lord, regarding 304B, law is, my lord, very clear. Only on, my lord, 304B, allegation of 304B is not enough. My lord, there is a burden of prosecution. The prosecution under section 30B of the IPC cannot escape from burden of proof that harassment to cruelty was related to the demand for dowry and such was caused soon before her death. The word dowry has to be understood as it is defined in section 2 of the Dowry Prohibition Act. Thus, there are three occasions related to dowry: before marriage, at the time of marriage, at an unending period. The custom of payment in connection with birth of child or other ceremonies are not involved within the ambit of dowry.
is there any cross?
My lord, regarding my lord, regarding my lord 304B, regarding
302B, is there anything that states clearly the accused has gone for a house 10 days prior to the incident, demanded rupees back from her, in week to meet his he made it clear my house.
Yes.
But anything that even by way of logic, not even by way of logic, what would you say regarding 113B of the evidence? Act?
my lord, here in this case, my lord, the prosecution is trying to protect their case. Right, my lord, there was a
What is
demand
the
of,
what is the interpretation of soon before her death?
regarding soon before death, my lord, it has comes out, my lord, the accused demanded 2 lakh.
Depends on the fact
That is true.
now PW2 is saying 10 days
10 days. PW say 10 days.
and
Someone
it is
says 2 months also.
because there the in-laws
Plus someone says, my lord, as per the version of my lord PW2,
most credible witness could be the mother
mother.
and the father.
My lord,
And others, the maternal uncles were told,
we're told.
but PW2 and PW3, they were in best position to say about whether they were many a time, in-laws may demand dowry, but parents not close to others.
That may be a situation,
But
but
whether 10 days before the
my lord, from my lord, submission would be, my lord, it is not soon before the incident, because 10 days,
because
my lord,
there was otherwise absolutely no process.
that I admit.
Prior to 10 days, you came, demanded back, and went out of the house, creating. And after 10 days, you came, ate, and thereafter the incident. Now, these cases,
These are all, my lord,
only thing, 113, to
Yes.
analyze B.
yes,
Only thing is that, firstly, within 7 years of marriage,
that part,
death was due to unnatural reason, and there was incident that we uh, cruelty for demanding dowry soon before the
yes,
Now, this only your case, in case of as regards the card conviction 304B, only your case hinges only whether it is soon before or not.
yes. My lord, from my submission
say
would be, my
will
lord,
reduce.
my submission would be, my lord, it is not soon before the incident, because it was, my lord, this, my lord, PW2, he depot, that it was demanded 10 days prior to the incident. 2 lakh was demanded, and since she could not meet his demand, he made a nuisance and left my house. And, my lord, regarding this, my lord, demanding of 2 lakh, my lord, it was not hardly my lord, just before the incident, my lord, it was not even told to other relatives also. And to that effect, my lord, regarding demanding of 2 lakh, my lord, there was no FIR, nothing, my lord. So, my lord, this version, my lord, this cannot be relied upon. That is my submission. My lord, this version, my lord, the
okay.
demanding of 2 lakhs, my lord,
Okay,
that is a, my lord,
that is a that there was demand for fee, and there was it is signed you are not condition.
that is not there. That is not required. It is not. I will not say that it is a signed contract. But, my lord, as per, my lord, our version, my lord, 10 days prior, and as per the, my lord, other witnesses say, someone said 1 month, someone says 2 months back, he was demanded dowry. And so, my lord, regarding that part, my lord, that story is not a believable story. And, my lord, normally it happens, my lord. When a, my lord, daughter died, my lord,
So there are two presumptions. There is another presumption regarding commitment of fee. The 130A.
Yes.
Right. And 113B. 113A is presumption of fact. 113B is presumption of law.
Yes.
So 106 and that you down, remove it done. Got activated perhaps in your
regarding, my lord,
because it is presumption of law. The only question is whether before or not because of absence of the cross-examination. You appears to have admitted defense. It is not a case of the defense that you did not come. Same thing. Right. To make it.
but it has been, my lord, during cross examination, it is clearly denied that I have never demanded 2 lakh
Wait.
from the cross examination.
Where? PW.
In the Azahar, I mentioned the names of 3 accused. A person wrote the Azahar on behalf of me. I know what is written in the Azahar. The marriage of my daughter was solemnized at Kamakya. The door of the room in which my daughter and son-in-law had slept was open. My lord,
Which part?
And the accused is a driver by profession. I do not remember whether I stated to police or not that we had got both of them shifted to Hosai from Shillong. A festivity was going on near our house on the day of incident, and the music was being played there. It is not a fact that door of the room in which my son-in-law
Where is it? Please point out.
and he did not squeeze her neck.
No, no, regarding game days.
My lord,
Game-
that regarding my lord, my lord, there is no
But I
denial my lord,
asked
in respect of
is
allegation of
regarding-
demanding 2 lakh.
Your visit to your in-laws house prior to 10 days of staying. That is what I asked.
That was not it. That was not.
Think not by way of a suggestion,
It was only by way of a
not even
suggestion.
not even by way of a suggestion.
It is not a fact that he was messaging my daughter and she was as she was unwell, and that he did not squeeze her neck. That means, my lord, it has been denied by the accused person that he did not squeeze the neck of her wife. Only that part. Regarding, my lord, as your lordship point out, regarding demanding of 2 lakh rupees and visiting 10 days prior
And
to the incident,
you elicited from like cross-examining PW3, page 16. He did not say it. You got it elicited. 6 lines.
my
My
mother,
son-in-law visited our house once during the period of
during that period of 2 months, I stated to police that
you got it elicited.
it
He was
is
not-
exactly,
did
my
not
lord, in
say-
the
He did not say in his brief with the father, but you got it elicited.
the vital on vital issue which required to be, my lord, right by the pen. Part, my lord, that part is missing. I admit. But, my lord, my submission
did
would
not-
be, my lord,
Put it.
Hello?
Did not put anything to
Yes.
PW.
but, my lord, simply denial, my lord, that I had not squeezed the neck
Okay.
of my,
That part is
my lord, only that much
demand
denial
of 2 lakh, 10 days. There was no whisper.
that I, because I can't go beyond the, my lord, cross-examination, which is not available, that is not available. But, my lord, my submission would be, my lord. Lord, here, my lord, the allegation is of, my lord, 304B. And, my lord, regarding dowry demand, there is no FIR, nothing as such. So, my lord, and prior to the incident, is not that they have informed anyone, or it has not been that, my lord, my lord, uh, informed to any other witnesses that he was demanded dowry of 2 lakh. So that part is not believable. That is my one submission. First submission.
Very clear. There were demands of doubt on several occasions.
On several occasions,
Several occasions.
but that
And
is
there was medical and medical response. Right. Just because police did not register on one offense, they had registered 30234.
yes,
That was
initially
not-
it was 30230.
What is 227?
Huh?
227 CRPC.
Yes.
Trial starts from the stage of 227 or from the
Richard,
It's not even your case that your wife guarded you to enter in the house. Nothing.
But the trial court held that deceased had injury on her neck, which is evident from inquest.
You encourage your counsel. It's not a appointed by
My lord, during the entire, my lord, evidence, entire case, I was behind the bar.
what your
Yes,
not that
court has
court has
appointed.
appointed any delegate.
Trial court held that deceased had injury on her neck, which is evident from inquest and postmortem report. The victim died due to strangulation, which is sufficient to cause death. My lord, trial court, my lord, held the victim died due to strangulation. Here, my lord, uh, and trial court also held that prosecution witness have thoroughly corroborated and proved the fact that dispute was demand of dowry of 2 lakh from deceased prior to the occurrence. And therefore, my lord, the trial court convicted the accused both under section 302 and 304B IP. But my lord, regarding my lord 304B part, it is true, my lord, that lord, I had not put any suggestions or any denial when BW 2 and 3 was cross-examined. That is an admitted fact. But my lord, it is also the burden of my lord prosecution to prove, my lord,
That is the first part and the opposed part.
cannot escape from the burden of proof that harassment to cruelty was related to demand of dowry. My lord,
What can I
regarding
say
my
to
lord, on that particular day, regarding demanding of dowry,
you? The
demanding,
soon before.
yes, my- that
Now,
was
what is
not
soon before?
happened
I have-
soon before.
I have asked you, what is soon before?
Soon before, as per my understanding, my lord, it should be very immediate.
Understanding will not do. What
Ah.
is it? What is it? Interpret.
Soon before, lordship, it
Those are
should be immediate. It should be immediate. But here, it has been, my lord, transpired that the incident of demanding dowry was made 10 days prior. And the occurrence took place 10 days thereafter. And, my lord, on that, my lord, day, my lord, it is not, no, any such allegation that after, my lord, entering into the house of the, there was some altercation took place in between the wife and the accused, or on that particular day, there is any whisper of demanding, any altercation took place in respect of demanding dowry, and there is nothing in respect of torturing on that particular day. On that particular day, there is no evidence as such regarding, my lord, any
now whether
altercation took
304B
place.
and 302 can go together.
My lord, from the, therefore, my lord, 304B, my lord, that part, my lord, is not believable, my lord, and 304B will not come. And, my lord, regarding, my lord, 302 in this case, my lord, as the case was projected like she was demanded dowry, she was demanded dowry, and due to not fulfilling the dowry demand, this incident happened. So, my lord, both are interlinked as per, my lord, 30, and as, my lord, 304B is not, my lord, my lord, proved, my lord. So my lord, it cannot be, my lord, unerringly pointing towards the accused that the accused had committed murder.
Imagine two things. Anything one. One is insect. And third, and the murder, the death was due to other than natural death, right? It may be suicide, it may be homicide, it may be accidental death. Now, suppose the lady, because of demand of dowry, poured out of frustration and all, and not able to withstand the physical and mental assault, poured kerosene or petrol on her and got herself burned. That would not be murder. But when somebody is instrumental in causing the death by bare hands, so that breathing is not possible. Now, whether both of this cannot go together, we can go together. In the first situation, if that is dowry death. But if it is suppose soon before this demand of dowry is proved, it can be 304B as well as 302, because the hands were instrumental in stopping the breeding of the disease, because you have not, it is not a case of suicide.
Well, it may
The other way would be homicide. Had it been a suicide, it would have been a 304B, simpliciter, without any offense of murder. But here, somebody's hands were instrumental in stopping the breeding process of a person.
What if may I?
Well, here,
I have
we resume after 5 minutes. We are resuming after 5 minutes.
my lord. Have, I
No,
just
I'm
want
not,
to-
I'm
I just
asking.
want to- I just want to place one thing regarding my lord soon before death. Regarding soon before death, and my lord, whether it is a my lord, death of my lord natural death, where whether it is a homicidal. Well, on that, two points. My lord, I just want
Oh, no,
please
then
accommodation, my
we'll
lord.
do the research after that. If you have not done the research, we'll do it.
Both for 302 as well as 304B. My lord, 302 is for a different, is for a specific offense. 304B, that is also for a specific offense. My lord, my lord,
302.
my lord,
Dowry death cannot be 302, but 304. Suppose it is not case of murder, but still they did dowry. It is dowry, so it is lesser punishment. But it is suicide. That can include 304B. 304B may not include 302, but 302 can include 304. Is it not?
my lord, it is fine, my lord. I just want a short accommodation to my lord
Yep.
make my legal submission, my lord. And regarding my lord soon before death, that is also one.
Clarify. regarding that doubt.
2021.
2021. Conclusion part.
2021.
304. Conclusion. The phrase soon before as appearing in section 3 cannot be construed to mean immediately before. The prosecution must establish a sense of proximate and live link between the dowry date and cruelty or harassment or by the husband or his
I think
I was right by approach. Section 304B, I think, does not take a pigeonhole approach in categorizing death as suicidal or accidental, which I was indicating. The reason for such non-categorizing is the fact that it occurring otherwise than normal circumstances can, in cases, be homicidal or suicidal or accidental. If it is suicidal, 304(2) may not come in, but it is homicidal, then 302.
both cannot be.
No, that is not the case. If it is suicidal, that I said, pour kerosene because failing to bear the brunt of physical and mental torture for demand of dowry, the wife might commit suicide by pouring kerosene. In that case, it would not be a case of homicide, 302, right? But if it is a case of homicide and fulfills the ingredients of 304B, and why should he be given only the lesser punishment?
Here, expression soon before her death used in the substantive section 304 PIP and section 113 of the Evidence Act is present with the idea of proximity test. No
All
definite
those
period.
judgments have been decided. Soon before is a relative term which is required to be considered under specific circumstances of each.
Yes.
And no straightforward formula can be laid down by fixing any time limit.
That is it.
In relation to dowry death, circumstances showing the existence of cruelty or harassment to the disease are not restricted to a particular instance, but normally refer to a course of conduct. Such conduct may be spread over a period of time. proximate and live link between the effect of cruelty based on a dowry demand and the consequential death is required to be proved by the prosecution. A demand of dowry, cruelty, or harassment based upon such demand and the date of death should not be too remote in time under which, under the circumstances, be treated as having become stale enough.
Not be too remote.
Question is prior to that, the lady had to live in her parents' house.
He was
That is one. Second circumstance, prior to 10 days, the husband made a demand or and created nuisance, left the his material. And after 10 days, he came, said that the incident led to death. And apparently, the death is not suicide. That the death is homicide. As deposed by PW. Then I heart attack is corroborated by the inquest as well as medical. This is appear heavy on the good report and the interrelation between report
it was it is small account. Tomorrow,
advances is not
or my lord, because my lord, in this case, my lord,
these are the things
regarding my lord, this case has been my lord, prosecution tried to protect that the accused person with his hand totally make of
being
this
raised the
is-
evidence.
But my lord,
also,
but my lord may
you should
kindly
have
see,
tried to argue on finer points.
Here in a case, Lordship, case of circumstances of evidence, but there is, in instant case, Lordship,
What circumstances? One eyewitness
no eyewitness is there.
Then-
Although the occurrence is taken place is at the four corners, but there is no denial from the side of the appellant that he was not present. That itself proof, my lord. Lordship, that he was the perpetrator of crime. And your lordship, allegation is that mother has was messaging the victim, but to that effect, there is no FIR or anything from the side of the accused person. Also. Lordship, yes, the first part is there.
sir, that was stated in my 313.
T-30.
313.
But T-30, can you bring a new story?
In 313, my
When
lord,
there is nothing, when you were given
regarding my lord, that
the first prosecution, right, evidence, there you got the opportunity to cross-examine the witness. Then, when 313 statement was made some statement, then you had the opportunity to lead the defense evidence claim to support it. There was nothing.
but my lord may kindly see my contract. In 313, my lord, I have said, 313, I have said, I came to the room, then I saw my mother-in-law giving massage to my wife.
So, any nothing without cross-examining the prosecution, whole lot of prosecution, they were not without doing anything. Just because you have been given the liberty in 313, you bring a new story
Lord, here, my lord, is a case of my lord 302 and 304B. My lord, when a case of my lord, say my lord, serious offense,
Yes, Mr.
so
I
it is
want to,
burden of my lord
I want
prosecution
to
is also
make
very
one
heavy.
more. I have to make one more.
Regarding my lord, demanding my lord, 2 lakh rupees. My lord, all the witness, my lord, except 2 my lord, others, all the witnesses, my lord, have denied my lord when my lord, they never stated so, my lord, when they have given their statement under section 161. That has been reflected from the my lord cross-examination of the my lord investigating officer.
So that can, can, it can-
Lord,
it- it- it-
My lord, as per my lord, my submission would be my lord in this case, my lord, from this from this evidence on record, there is the demand of dowry regarding demand of 2 lakh rupees that was not proved. Though I have not put any specific cross-examination.
there is a- but
What the Supreme Court has observed, a duty is also cast on the counsel of the accused.
Yes.
To prepare his defense, since the inception of the trial, with due caution, keeping in consideration the peculiarities of section 304B IPC, read with section 113B of the Evidence Act. Duty was cast up of the peculiarities of B and into the provisions of presumption of law
Yes.
incorporated in section 113B of dowry tax. So you have to prepare, you ought to have prepared your defense,
At the
your
very
line, very
initial
beginning.
stage of the evidence. But my lord, in my case, as per my lord, it was my lord framed under when the charge was framed under both 302 and 304B. And my lord, requirement of 304B is that my lord, the prosecution under section 304B of IPC cannot escape from the burden of proof that the harassment to cruelty was related to demand for dowry, and such was caused soon before her death. My lord, regarding that, regarding my lord demand of my lord 2 lakhs and all,
Three, money that debt should be caused by the date of marriage.
and here
Second,
admittedly
the
within
date
3 years.
should be unnatural death. Thirdly, there should be demand or for dowry or harassment dowry, soon before the date. Now, soon before is a relative term that means that be read as immediately before. There should be live thing.
Regarding my lord life thing, my lord, there is no such allegation, no such evidence as such that, because my lord 10 days, if we assume the version of the PW2, that 10 days prior to the occurrence, he demanded dowry, and as she failed to meet the dowry demand, therefore he committed some nuisance. Only that much, man. But thereafter, man, well, there is no such allegation, no such evidence as such that he again created nuisance, and on that particular day also he he did some nuisance and thereafter he committed, he
Point taken.
The ingredients of Christopher, I think it has been fulfilled, my lord, in the incident. Because the marriage has taken place 3 years prior to that incident. There was a demand of dowry. As the victim and the family members could not fulfill it, lordship, there was a assault, there was torture, my lord, as a result of which she came back to her parental home, my lord. And your lordship, it has come up with evidence of PW2, my lord. Lordship, page 13, para 12, second para. On 116, the accused came to our house again and said that he would not subject my daughter to torture, demanding money. So, your lordship, there was demand, my lord, and there was live fleeing, my lord, because the occurrence had taken place on 17/1/2016. I told my son-in-law to stay in my house. He went out for a walk after taking evening tea and returning home. He took the meal. Thereafter, I told my son-in-law to stay in a room along with my daughter. So, your lordship, the accused person was very much present with the victim at a relevant point of time. At around 12:30 a.m., I heard the child of my daughter crying, whereupon I entered that room and saw my son-in-law strangulating my daughter by sitting upon her chest. Then I removed the hands of my son-in-law and sounded an alarm. My husband got up and came there. Other people also arrived there. The accused tried to flee, but he could not do so. My daughter was finding it difficult to breathe. Then we took my daughter to Hosai Civil Hospital in an auto, but since she was not kept there, we took her to Ham, where she was declared dead. The accused was handed over to the police that very night. Police took the dead body of my daughter away. I lost the Ezahar the following day, so and so. The dead body of my daughter was sent for PM examination. Then cross, my lord. In the Ezahar, I mentioned the names of 3 accused. A person wrote the Ezahar on behalf of me. I know what is written in the Ezahar. The marriage of my daughter was solemnized as Kamekha. The door of the room in which my daughter and son-in-law was kept was open. I think that was not stated the one. The accused is the driver by profession. I do not remember whether I stated to police or not that we had got both of them shifted to Hosai from Shillong. A festivity was going on near our house on the day of the incident, and the music was being played there. It is not a fact that the door of the room in which my son-in-law had slept was not closed. It is not a fact that I had not removed the hand of the accused from my daughter's neck, and that the accused had not squeezed the neck of my daughter. It is not a fact that I did not state to the police that I had removed the hands of the so-and-so. At the time of incident, Monica Montal and Taposi Das came to our house. It is not a fact that he was massaging my daughter as she was unwell, and that he did not squeeze her neck. Lordship, regarding the demand of dowry, there, cross-examination. So the portion as regards demand of dowry in examination sheet. So in the case of the presence of the accused person, it has not been denied. Even my learned counsel is submitting today, but he was very much present. So an explanation from the side of the accused person is required. And if he gives a false explanation to the defendant, give additional link. But that is as regards a case of circumstantial evidence when the commission of offences taken place in the 4 corners of the house. In the instant case, although the offence has been committed in the 4 corners of the house, incidentally, the PW2 has also witnessed the occurrence. It gives lordship, it strengthens the prosecution case. Lordship, may I cite one citation? Remove one.
Remove one. Read the answer.
That
That's
it
the
remove,
principle of 106 will come
no,
in other
Yes.
texts also.
Yes. eyewitness also.
This is the one.
I think pardon the lordship may not come because when direct evidence is there, because eyewitness, my lord, although it was wee hours, 12:30 a.m., she was hearing hue and cry of the child. The PW2 immediately went and she saw the strangulation. So in that account, my lord, my lord,
Say that when looking inside a room, two persons were there, and one came out unscathed. Another person is there. It's hardened is on him to explain the situation,
yes,
what had happened inside her.
my
Now,
but that
that principle will
may not
also
be
applicable
applicable.
when an eyewitness has been down.
May not be applicable because direct evidence is there, lordship. Even if a single witness is there, my lord, it's enough.
Full of evidence.
My lord,
101 to 105.
my lord.
It is sort of if something be left for the
Because they are saying door was open, the possibility of coming another person. But that they have not taken. But 161, I did not find that the PW2 has stated the door of the room was open.
Professor. Only on the point, don't not repeat whatever you have said, you have heard. Only on the soon before, immediate before,
Whether 10 days is enough.
another one,
So,
whether 304B can be can go without
Soon before 304 30.
that's all.
My lord, I just want to out one more thing. My lord, here, my lord, it has been, my lord, protected that he, due to the throttling by hand, he exceeds his height. That is the what comes from the version of the prosecution. Well, my lord, may I kindly see one very important aspect. Page 32 of the paper. My lord, there, it is the evidence of, my lord, cross-examination part of the, my lord, Ayub. Here it has been very clearly he mentioned no sufficient evidence was found against the accused party.
Accused persons. There were three.
My lord, I am leaving that. Thereafter,
That
it is not a fact.
He cannot say
My lord,
after
not,
submitting charge sheet.
my lord, I am leaving that. Thereafter, not some impression of the accused has been taken by me, and the injury mark of the dead body did not match with the dead body's injuries.
If he is not taking some impression,
My lord,
there is no question of matching.
my lord, that is why, my lord, that is a
He
vital
is-
lapse, my lord.
that will be defective investigation amounting to result in acquittal of the again, the harm impression of the accused.
Yes,
Right? Harm impression of the accused. That might be a case of defective investigation. Right? Because the next part is that since one has not taken the thumb impression, there is no question of matching. Mr. Datta, please think reasonably.
Yes.
Second part is dependent on the first part. No thumb impression of the accused has been taken by him. Okay? Okay? If there is no thumbprint collected, there is no question of matching. Am I clear?
Yes.
So, whether non-collection of the thumb impression is a case of defective investigation and which will result into acquittal, you have to address on that.
Yes, my
You have to address on that. Second part is dependent on the first part. Am I clear?
Yes.
So, whether non-collection of the thumb impression of the accused by the IO would result into a defective investigation, and such defective investigation whether would result in acquittal of the accused vis-a-vis the evidence on record already available. You have to structure your and formulate your argument on that line.
I will
Nothing
address
else.
on that also. I will address.
Just
that-
because you read that and will not do.
Well, I would like
Am I
to.
clear?
Yes, sir. So on that point also,
But not, you have to be precise.
yes, sir.
Not here and there, not here and
Well, very specific. Soon before 304B, 302 IPC, and on this point. Yes.
There is requirement of taking part.
My lord, here my submission would be because my lord, the prosecution has projected that the incident was happened by throttling by his hand. And my lord, if your lordship go by the injury report also and the statement of the my lord doctor, here your lordship will find PW10. I did not mention specifically how and by what substance the mechanical obstruction was caused. I did not mention the time of death of person. Death can be caused immediately within a second after obstruction or throttling. It is not a, so my lord, whether my lord, if it was caused due to my lord throttling, my lord, that my lord injury mark, my lord, whether that injury mark
See,
will
Mr.
be found.
Doctor, you have to base your submission on the basis of some solidity. That's you read it and read it time and again.
Yes, I will address on,
That is not the
not on here and
Yes.
that is
that if you tell a lie for 100 times, it will become a truth.
I'm just trying to say. But is the
With some basis.
yes,
Make some
definitely,
impression.
definitely.
The
On
some impression is condition precedent for a case of sanction. Non-collection of some impression is a case of effective investigation and it is fatal for the case, for the prosecution. That has to be the line of submission. Reading here and there will not do. Why? When you find out
No,
principle or logical, it also applicable in a case.
direct
Direct evidence. Direct evidence. Because otherwise, what is within the exclusive
the spatial knowledge.
spatial knowledge of the
Okay.
accused. Right? Suppose the qualification of the accused comes. Prosecution may not be established or date of part. It is within his spatial knowledge. He can say, likewise, in Irkan, within the room, that man came out without any injury. But the lady or whatever the other died. So he has to explain because room was, there were no one else. But here is a case, there was somebody who saw it. Then
No,
immediately,
Lordship, yes,
the husband also came.
husband followed,
Husband of the
PW2,
who came.
yes,
Then neighbors came. I
Yes.
have saw the sketch map.
my lord.
They are very in close vicinity.
Subhas and the lady,
Right.
yes, Tapuch.
All those were in close vicinity. They immediately came. So the process was part of the same, you can say, transaction. Section 6. Right.
That matter, ransom matter, partner.
Lord, what to-
Time is not granted to Mr. Dotto. Time is granted for the interest of the appellant.
Yes, yes. I will
Because
try my-
Mr. Dotto has not
satisfy on their
Dotto
legality.
is
I will
found-
try my best.
found to be not totally fit.
How like-
Goa, America, Guwahati.
Guwahati, my lord. Manik Nagar.